We just again want to welcome you to What You Need Extended School Year. This is Tuesday, February 15th, 2022. And our disclaimer, the ARC of Lehigh, Northampton County's Advocacy Department does not employ lawyers nor provide legal advice. This training or any other provided by the ARC's Advocacy Department does not constitute or imply the endorsement, recommendation, or favoring of the providing party or any employees or contractors acting on its behalf. This webinar is being provided for educational and informative purposes only. All right, so thank you so much, Jackie. It is now your turn to share.
Yep, what you need to know, extended school year. So we'll talk a little bit as we go through, not only about extended school year, but about some of the areas that commonly overlap with it. Here's a little bit of a roadmap for us, if you will. We'll talk about terminology and definitions, make sure that when we're using acronyms, everybody is on board with what those mean. If at any point you're not sure about something, please feel free to note that as a question. You can put that in the question and answer or in the chat, or raise your hand. In addition, we'll talk about just what is ESY, what is it supposed to be, what is it not? There are many things that I've heard over the years that get confused with. So we'll try to kind of compare and contrast there. Who qualifies for ESY? What are the criteria for qualifying and how would that be decided? We'll talk about when ESY eligibility is determined and for which student. So everybody can kind of have that timeline in their mind. And then ESY disputes. What happens if a parent disagrees with the eligibility determination? What happens if a parent disagrees with the content of an offered ESY program? And then finally, just a brief word on extended school year and COVID-19 compensatory services. That is a whole topic unto itself, but there is a bit of confusion in this area, so I'd like to just briefly touch upon that. Okay, so here are some terms that you may hear me using. I'll try for the most part to reference the longer term and the shorter for many of them as we go through, except for extended school year. That one I will mostly refer to as ESY. So first, of course, extended school year is ESY. We'll talk all about that as we go through. The next, NOREP, Notice of Recommended Educational Placement / PWN, prior written notice. This is the document that is issued to parents to inform them of a change or refusal to change the provision of FAPE or an evaluation for a student with a disability. So after an IEP meeting, to make those changes in the proposed IEP, parent receives that NOREP or prior written notice to let them know what the changes are, and then for the parent to provide consent. It's important to note that consent is only required for a district to go through with a recommendation for the initial provision of services. After that, written consent is not required from the parent. It will always be asked. The LEA, the local education agency, will wait 10 days, see if the parent is going to agree or disagree. After those 10 days, if there is no response, typically the school district is going to just put that change into effect. The next term we're going to talk a little bit about is those COVID-19 compensatory services. These are often abbreviated to CCS. And those are a new offering in a way. It comes out of non-binding guidance from the Pennsylvania Department of Education. And in that non-binding guidance, the state is really trying to reckon with what do we do with this learning loss that we know students with disabilities have suffered due to the pandemic and due to virtual education or hybrid education, the use of kind of non-traditional or alternative learning modalities. So that describes a process for IEP teams to determine whether a student has regressed, and if so, whether a student needs some additional services, COVID-19 compensatory services, to be provided to bring them back to the levels they should have been at. Really not, as I said, at issue in this presentation. I did last week have the the chance to present on this to the ARC. If you're interested in receiving that PowerPoint as well, please just let us know. We'd be happy to send you a copy. Okay, the next acronym here is LEA, Local Educational Agency. For our purposes, that is a school district, charter school, cyber charter school, a public school entity that is responsible for the special education and related services for students with disabilities. The next one is FAPE, Free Appropriate Public Education. This is the standard that the school district has to provide for a student with a disability. They need to provide a free, appropriate public education. We'll talk a bit about what goes into that. And then finally, related services is a term you may hear me say. Those are services that may also be included in an IEP. Typically, they're things like speech, OT, PT, but there are others that can qualify as related services as well. Okay, so our first topic, what is ESY, or Extended School Year? The Individuals with Disabilities Education Act, that's the law that produces the child's entitlement to special education and related services and outlines what an IEP is and what needs to go into it. So the IDEA, as we call it, defines extended school year to mean special education and related services that are provided to a child with a disability beyond the normal school year in accordance with the child's IEP and at no cost to the parents. The public agency, so in this case, the school district, charter school, or cyber charter school, can't limit ESY services to just one particular or couple of particular categories of disability. Every student has to be individually assessed. And they also can't unilaterally limit the type, amount, or duration of those services. So there can't just be a one size fits all. It has to be something that is individualized to the student. So takeaways from this, what does that really mean in practical, everyday language? One, it's services that are going to be provided outside of the regular 180 days of the typical school year. And it's services for students with disabilities that are based on those disabilities to enable them to continue to make progress. Students are entitled to ESY if they need it as part of their FAPE. So it's like all things in special education, it's not necessarily, would this be best for the student? Would this produce the best outcome? But rather, is it appropriate as part of a free, appropriate public education? I hear that sometimes kind of summed up as, parents are entitled to a Chevy and not a Cadillac. The only caveat I usually share with that is, yes, you may be entitled to a Chevy and not a Cadillac, but you're also entitled to more than a bicycle. So we have to kind of figure out on that spectrum, what is appropriate for that student for them to make meaningful educational progress. So what goes into a FAPE here? FAPE is individualized. It's designed to meet the unique needs of the child. The needs should be memorialized in the IEP and listed, but if that list is not, a complete list of all the students' needs, any other source of information about the students' needs can be considered as well. The evaluation report may have more information than what's in there, but essentially whatever the students' needs are, they need to be met, and this IEP is supposed to be the vehicle to provide for that. And then the student needs to be able to make meaningful educational progress with these special education services. And the whole point is to prepare them for further education, employment, and independent living. So really something that's meant to be useful to that individual to get him or her to further education, employment, or independent living. A couple things ESY is not. ESY is not summer school in the kind of colloquial sense that some people think of it, where maybe somebody has failed a course or something and they now need to go to summer school. It's not anything like that. It's not credit recovery. So again, it's not a situation where maybe parents have to pay for a student to take a credit recovery course for them to bring their grade up in certain areas where they may have missed assignments or failed tests or quizzes. And it's also not the same as those COVID-19 compensatory services. COVID-19 compensatory services, as we'll talk about, are not part of FAPE. They're meant to be a vehicle for just addressing that learning loss. And ESY is really meant to be a FAPE offering. It goes into the IEP. It is part of the student's program. So who qualifies for extended school year? There are a number of factors in Pennsylvania that are considered for eligibility. The main thing I like to point out to parents about this is that recoupment and regression are not the only factors here, even though they're the ones that get discussed the most often. Those are not actually the only ways that a student can qualify. So factors for eligibility include regression, whether the student reverts to a lower level of functioning. Typically, we're going to be looking at data to look at that and understand what the impact of interruptions in the educational program are. Recoupment, the student's ability to recover skills after there has been regression. All students over the summer may experience a little bit of regression and may need the beginning of the school year for some recoupment. The question here for this part of it is, is this more than would be expected based on the student's disability? Are those disability related factors such that the student really needs the services beyond those 180 days? So regression and recoupment in regard to IEP goals and objectives, whether the student's difficulties with regression and recoupment make it unlikely that the student will maintain skills and behaviors relevant to the goals and objectives. This is where I really see most IEP teams focus. What I would say here is that, yes, a review of the goals and the data is so important to this, but what I would caution parents to do here is really make sure that your IEP has the right goals. So if a team is taking data on some of the right goals, but missing areas of need that have no goal, then this analysis is really not going to get at everything the student needs. And it may lead to an ESY eligibility determination that just either says there's no eligibility when maybe there should be, or says there's eligibility only for a portion of what the student really needs, and the student may need something more robust. So, again, the IEP is written in a way to identify the needs of the student. And then, in my opinion, the goals should really track those needs so that the parent is receiving regular progress monitoring to be able to watch that data as they go. And then also so that when we do these types of factor-based data analysis, we know that we're looking at all of the students' needs and not just some of them. Other factors are interruption of potential mastered skills. So we're looking at important skills or behaviors and how they will be interrupted. Similarly, looking at achieving self-sufficiency and independence. So the team can consider the extent to which a skill is particularly crucial for the student to meet the IEP goals. And withdrawal from academics, the extent to which interruptions result in the student's withdrawal from the learning process. So these are all things that would be factors for eligibility. And then finally, the severe disability, whether student's disability is severe. This we'll talk about a bit later. Generally, we would call this an Armstrong Group. So those are students with disabilities such as autism, serious emotional disturbance, severe intellectual disability, multiple disabilities. Okay, so what kinds of information should the IEP team be looking at? Progress on goals, as I said, is probably the most common to look at, but it is, again, not the only one. So just as regression and recoupment is the most common way to hear teams kind of explore this question of eligibility, it's not the only factor that needs to be considered. So too, just as goals and goal progress is one way and one factor that needs to be considered, it's not the only source of information, and there are others that should be as well. So teams should also be looking at reports from parents of any, negative changes in adaptive behaviors or other skills. So, really, if you're a parent and you're talking about your IEP team, make sure they understand what, especially the summer break, can look like for your child. And if there are some, particular challenges that come up, make sure that the team knows kind of concretely what those look like. They can also look at medical reports. They can look at any other challenges that are increased during the breaks in the educational services, observations from educators or parents and team members, test results, curriculum-based assessments. So really what you could see is that this is a more robust conversation than just, are you meeting your goals? Did you meet them despite another break that we had in services, those types of discussions. So eligibility is established if those factors make it unlikely that the student will maintain skills and behaviors relevant to IEP goals and objectives. That's how it's explained in general. I do want to draw your attention to this basic educational circular. A lot of the information that will come as we go further throughout this presentation is drawn from that. It's a really great resource. It's non-binding, but the Pennsylvania Department of Education puts out these basic education circulars on a variety of topics, and they update them here or there. You can see that the extended school year one hasn't been updated since 2013, but the information in it is still reliable. These are definitely areas that, the school districts and charter schools themselves will look to these circulars to kind of answer questions. So it's a great resource. It's free. It's on the Pennsylvania Department of Education website, and parents can access this to kind of read up on some topics and get some more information if there's anything that they're not sure about. So if there's an area that you have a question about, it could be good to just do a little search there to see if there's anything on it. There are basic educational circulars on things like transition from EI and on attendance and graduation. So just things that I know many people out there have questions about. And then some other areas that you can look at too, the Bureau of Special Education, the Pennsylvania Training and Technical Assistant Network, they both have some information about ESY. So again, not binding in the sense that, a court isn't required to find along the lines of this guidance. Unlike the law, a court is required to implement the law, but not this. But it's helpful to understand. So this guidance says the IEP team will determine which services and how much will be provided during the extended school year. And they may decide that the student will continue all services received during the regular school year, or may decide that the student will only receive a portion. So based on each student, it's not just eligibility for ESY, but they're also going to decide eligibility based on the different needs that the student has. So a student may have a need to work on a particular area in ESY, but not have that same need for another area, even though it's an area covered by the IEP. So it's really kind of a complex decision that unfolds. For a child to be found eligible, it's not necessary for the child to first experience regression during an interruption in educational programming. I think that this is so important because I feel that in practice, what I have found is that there's a lot of, well, we have to wait and see. We have to wait and see. We have to wait and see. And the point of saying that there is no requirement for regression to happen first is, one, to ensure that the child receives FAPE, but two, to ensure that parents can timely exercise their rights if they need to. So if we keep kind of, punting, so to speak, the decision to wait and see if there is enough regression, we might not be able to make that eligibility determination in a timely manner for the parents to be able to exercise their rights if they need to go, potentially to mediation or due process. So the timing of when the ESY eligibility determination is made is split into two groups of students. The first group of students we generally refer to as the Armstrong Group. This comes out of a federal court decision. The Eastern District of Pennsylvania back in 1979 came out with their decision, Armstrong v. Klein. And in that group, they said would be students with the most severe disabilities, such as autism / pervasive developmental disorder, serious emotional disturbance, severe intellectual disability, degenerative impairments with mental involvement, and severe multiple disabilities. So students who fall in that group would be considered Armstrong Group students. And for those students, there is a specific set of deadlines for when the team must meet and when the team is going to issue its recommendation. So for the Armstrong Group, the IEP meeting for ESY eligibility has to occur by February 28th of the year before that ESY program. And the NORAP has to be issued by March 31st. Now, not every student is a student perfectly in these timelines. So for example, if someone transfers after February 28th, what is the school district supposed to do? Well, in that case, if ESY was already in their IEP from another Pennsylvania school district or charter school, then ESY would be considered part of the student's pendant program. And the new receiving school district or charter school should implement that program unless and until there's an IEP meeting and a new team considers the student's needs and issues a NORAP. For students who are enrolling later than February 28th and did not have ESY or no determination had been made, then really, the guidance says that the school district or charter school should be making that determination at the IEP meeting. So you would think at that point that, a student should have an IEP meeting pretty quickly with their transfer to delineate the program. And of course, if parents know that this is a particular concern, maybe they didn't have a determination from their last school district, maybe they disagreed with it and now they're in a new one, parents can always request an IEP meeting at any time and make sure, that they make that request in writing, preferably, and say that you believe that the student should qualify for extended school year services. The non-Armstrong group, so students with disabilities, but not with those severe disabilities, does not have the same deadlines, but it's really important to note that all students with disabilities need to be considered for ESY eligibility. So students who have, other types of disabilities still need to be considered, even if they're not in the Armstrong group. It's just that we don't have any hard and fast deadline about the timing. So the non-Armstrong group doesn't have the same deadlines, but it still needs to be done in a timely manner. So what I would be looking at there, naturally is, were parents able to participate in that IEP meeting? Was it noticed? Was there enough time for the team to meet and a NORAP to be issued before, this program needs to be going into place? We'll talk a little bit at the end about dispute resolution. One good thing to note is that if a parent is filing a due process request based on ESY, based on the eligibility or the program that's provided, that would be an expedited hearing. So the law really wants to make sure that parents have plenty of time and that they don't get stuck in a long process if this is a decision that needs to be made. You don't want to get your hearing officer decision on September 1st to say, yes, ESY eligibility should have been granted. If a parent requests ESY, the request must be treated as a change in the provision of FAPE. So this is important. This means that this has to be something that's taken seriously. The team has to meet, they have to review and come to a decision. This should not be a predetermined decision. The parent should be involved in it. And then following the meeting, parents should get that NORAP or prior written notice with the team's recommendation so that they can then exercise their options. They can approve it, they cannot approve it, and if they don't approve it, they might choose to go to mediation or due process. Students who have aged out or received a regular high school diploma. So students in Pennsylvania age out when they turn 21. However, if they turn 21 during the school year, they may be entitled to get the following ESY. So if they turned 21 in February 2022, they may be entitled to ESY 2022. That's an IEP team decision. So the IEP team would review and would make a determination about whether extended school year is necessary for that student for that subsequent summer. And then the student would not take their diploma, at the end of the regular school year. Rather, they would complete the extended school year program, and then the district or charter school would issue that NORAP or prior written notice to exit the student from special education due to aging out. Students may still be eligible for ESY even if they have fulfilled all of the credits to graduate, or even if they're graduating with a regular high school diploma. Again, the student would just not take the diploma at that time, complete ESY, and then at that point, the diploma and the NORAP should be issued. Okay, so this is, I think, one of the biggest questions here. There's no real answer to it, but I just want to bring it up for our discussion and for our consideration. Is ESY always the same weeks and times? Well, the answer is kind of yes and no. ESY programs are often held during the summer, but it can be at other times, and it can be for longer than what the typical recommended ESY program would constitute. And the reason is, again, because it needs to be individualized for the student. So for some students, 4 or 5 weeks, 4 days a week, that's kind of typical. I've seen that, across many parts of the state. For some students, that's not going to be enough based on their disabilities, and they may need, virtually continuous programming, or they may need something that we might think of as a 12-month program, and that period of time in the summer would not be sufficient. For other students, it will be. So it kind of is going to depend on the particular student. Some hearing officers, though, have specifically approved that it's okay for a district to have kind of a general set of, this is when we have ESY. They've likened it, those hearing officers, to saying, well, during the school year, schools have a typical school day, school hours. They have typical school weeks. We know they have 180 school days. They're kind of only doing the same thing to say, all right, we're going to have our teachers and our staff available at these locations for these hours. And as long as that program that is happening is individualized there, the hearing officers in those cases have not always disturbed the ESY decision. So there's kind of this tension here. There, some cases that are really focusing on, no, it needs to be individualized, maybe that program didn't meet the student's needs, and others saying, just because it's set during a set period of time or weeks doesn't mean it's not individualized. And, in those cases, they found that programs were sufficiently individualized. So it's really going to be down to that particular student, what he or she needs, and what, the records and data have shown for that student over time. If there are disputes, though, parents, I think, really need to understand what their options are. And I say parents, but not just parents. I know I'm speaking to many professionals out there as well. But understanding where the dispute ends up and how that looks can help sometimes plan for what the process could look like. So first thing I just tell everybody whenever I'm talking about dispute resolution is that there's generally a 2-year statute of limitations. So that is 2 years from when the parents knew or should have known that they need to initiate a filing. Otherwise, claims from more than 2 years ago may be outside of the statute of limitations and barred. So 2 years from when a parent knew or should have known that the student's rights were violated, they need to actually go ahead and act on it in a legal sense. Otherwise, those claims may be barred. It could be a very complicated legal analysis. In 2015, we were handed a new decision from the Third Circuit. And with that decision, there was a lot of kind of change in the way attorneys at least argue the statute of limitations. And so now we've seen that decision and some lower court decisions, and it's just not totally settled in terms of the language in the statute and in terms of the language in this decision as to what exactly does the parent have to know. Do they have to know just that a school district handed me a NORAP, and therefore theoretically you knew of everything in the program, or do you have to know that something in the program is wrong or harming the child? That's kind of where the debate falls. So because it's a complicated legal analysis, if you're concerned or you're not sure, I just always say, try to seek help. There are free resources out there to do, free consultations by attorneys. My office and other offices offer this, just to get that advice and make sure you're not sitting on claims because they may in fact be barred. So if a parent disagrees with the ESY determination, their options generally would be a due process hearing. Those are in front of the Office for Dispute Resolution. They're independent hearing officers who are hearing those cases. They act essentially like a judge. So it's an administrative hearing. It's kind of less formal than a full court case, more formal than the IEP or mediation process. There's a transcript, and that would result in a final decision after the presentation of witnesses and evidence. And the hearing officer would decide, does the student need extended school year services, and are the services that were offered appropriate? Parents can also pursue mediation. Mediation is voluntary. That's important to know. So you can ask for mediation from your school district or charter school, but they can decline it if they don't want to go to mediation. That's, both parties have that choice. If both sides do decide to mediate, a mediator will come work with both sides, try to see if there's a way to resolve the dispute outside of any due process hearing. Whenever you get a NORAP, you should get or be directed to the procedural safeguards notice. That's, that kind of long document that outlines all of the parents' rights. It also provides information on what to do in the event of a dispute. And there's also a lot of information out there on the Office for Dispute Resolution's website. So I've highlighted that there, odr-pa.org, including a guide to due process and mediation and the forms that would need to be used. The one thing for timeliness that I want everyone to understand is that if you need pendency, if you need the ability to have the student remain in the last agreed upon placement, then you want to make sure that within 10 days of receiving the NORAP that is trying to change that placement, that you actively file for mediation or due process, not just hand back the NORAP saying that you want that to the charter school or the school district, but actively send it to the Office for Dispute Resolution so that it gets filed. So what would that look like? That would look essentially, in most cases, like a student in the ESY context, whose student who previously qualified for ESY, and the team is now saying, no, we're going to change that eligibility determination, and the student is no longer going to qualify. If that is a decision that you do not want to go into effect within 10 days of receiving that NORAP, you would want to actively file for due process or mediation. There are other available dispute resolution options like facilitated IEP meetings. Those can be extremely helpful, but they don't have the effect of triggering pendency. It's only mediation or due process that will do that. Okay, so if a parent files on files for a due process hearing for an extended school year issue, as I mentioned before, they'll get an expedited hearing. So that would be a hearing that has faster deadlines for when that decision is going to be issued. Expedited hearings are going to happen when the parent disagrees with the eligibility determination. so that the child is not eligible for extended school year, or also when the parent disagrees with the types of services that would be provided to the child. And the reason for this is essentially, as I mentioned, we want to make sure that you don't get a decision after ESY that ESY should have been provided. So we want to make sure that those cases move pretty extraordinarily fast. The expedited timeline means that the decision, the hearing officer's written decision, would be sent to the parties no later than 30 days after the complaint was filed. So that's a really quick turnaround. And typically the hearing is going to be held just within 15 calendar days of the request. There are no exceptions permitted to the timeline, so neither party would be able to ask for a continuance or ask for a different hearing date. The timeline, really is going to be held, and hearing officers generally will not issue something like a conditional dismissal. It has to be done within these 30 days, and we're not going to be able to push it beyond that. All right, so what is the difference between CCS, those COVID-19 compensatory services, and extended school year? I think the reason for the confusion between these is that many school districts and charter schools have used and built on to their ESY programs to provide those COVID-19 compensatory services for a variety of reasons. And because of that, it's become unclear to many, is it really the same thing as ESY? Are you, because of COVID, are you now qualifying for ESY where you didn't, or is ESY just longer? There's just a lot of confusion. So what are COVID-19 compensatory services? Those are services as determined by an IEP team to remedy a student's skill or behavior loss or lack of progress that resulted from the inability to provide FAPE while using alternative instructional models due to the pandemic. So essentially, it's services that are necessary because of a loss of skills or a lack of progress due to using virtual, hybrid, alternative instructional models that were necessitated due to the pandemic. COVID-19 compensatory services are decided by the IEP team. Important to note that parents are, of course, part of that team and should be part of the discussion, and it shouldn't be a predetermined outcome. They should be decided after the student is kind of back into their IEP services for a while, had time for some recoupment instruction, and then at that point considered whether there is still a loss of skills, and then whether those COVID-19 compensatory services are necessary. COVID-19 compensatory services are typically provided by the school team. So it would usually look like services that the school is going to provide outside of regular school hours as agreed upon by the IEP team. In some circumstances, parents and school teams can agree to something other than that construct, but that's kind of the norm. One thing to note, one big difference here is that COVID-19 compensatory services are not part of FAPE. So they don't get added into the IEP. They're not part of a student's entitlement to a free appropriate public education or the special education related services that the student needs during the school year due to his disabilities. And because of that, the school district or charter school is not required to provide transportation for COVID-19 compensatory services. ESY, on the other hand, is part of FAPE. It is part of the FAPE offer, and it needs to be provided at no cost to the parents, and it needs to have transportation provided as well. All right, I think that brings us to the end of this. And reserve some time for questions that you may have. Thank you, everyone, so much. If you're signing off now, I really appreciate you joining us. If you have any additional questions, you can reach out to me, and as we mentioned, the PowerPoint will be sent to you. And I've enjoyed presenting here, and I'm looking forward to chatting with anyone who does have questions.
Great. Thank you so much, Jackie. We thoroughly appreciated this presentation. Very well broken down. We love using terminology as we tell our families all the time. Special education sometimes has its own language. So learning to navigate that is a challenge all by itself. So thank you for your time this evening.